Hi, this is Anita from Real Estate Crunch. A question that a lot of people ask or wonder is, can I go into someone's house without permission to get my furniture out? Let's say that you were staying at someone's place, you were renting from them, you left your furniture in there, you want to go in and get your furniture out, or you were staying with somebody, you had a bad relationship with them, you want to go in and you want to get your furniture out. Can you go in there without permission to get your furniture out? This becomes a really interesting question because this is a lot about, especially in the United States, about how property is viewed and the laws of property. Going into someone's house without permission is not allowed. So going into someone's house for any reason, even if your furniture or possessions are in there without permission, is considered to be illegal and is not allowed. You must have permission to enter someone's house without consent. And this is pretty standard, throughout most of the parts of the world, a basic type of law, that you just can't go into someone's house and enter it and take things out, even if they are considered your things, without their consent, because it is considered to be illegal. It is actually considered to be a crime. It is considered to be breaking an entry. If you go into someone's house and you take out furniture, even if it's your furniture, and even if you own it yourself, it is considered illegal to go in and to take out that furniture. Under the law, a person commits a crime of burglary by entering a building without permission. If you have a key and enter a building, the law could view that as you have permission, but how they view this will depend upon the actual circumstance. In other words, if you have a key and you have permission and they've given you permission, usually they will say, look, you've had permission to go in and take things out. But if you don't have a key and you actually break the door down or you cut the lock open to get your things out, that is considered to be burglary. And by breaking a window to enter a premise usually shows that you did not have permission. Cutting a lock shows that you did not have permission. The law views that a crime's already been committed as soon as you enter the building, even if no theft or felony occurred. Illegal entry is also considered a crime. So even if you just cut down the lock and step your foot in, you don't take anything out, it is still considered a crime to enter someone's property without permission. So let's say that you have furniture in somebody else's house and you want to get that furniture out and you have a bad relationship with them. You're not able to ask them, you're not able to contact them, or for whatever reasons, what can you do? You can have, first of all, a civil standby procedure, which a civil standby procedure is a legal option of getting your property back. If there's someone that's going to maybe be aggressive or there can be other problems, you need to show that this could be an issue and that you need to help to retrieve your property. So it usually consists of a sheriff or a police or an officer accompany the person into the house to reclaim the property where the property is located. In some jurisdictions, the individual is told to stay near the property until an officer can be dispatched. Here are some reasons when a civil standby procedure can usually be used. A person is legally barred from contacting another person, so the civil standby procedure can be an exception to that ban. So let's say, for example, there's a restraining order out, so you're not legally supposed to contact that person. So then you can go to the police and you can tell the police, I need to get my property out, and this can be an exception to it. It may also limit a person's time retrieving personal property. They may be told you have 10 or 15 minutes to get the property out. And, moving such more significant things such as furniture may take some time. So you must be told that. So that could also be a problem too. So you need to understand that. You can do a lawsuit. If a person is holding your personal property, a landlord, most jurisdictions and states have specific laws about how you can get your property and obtain your personal property from your landlord. So, you can file a type of lawsuit to be able to get the property back. You can get a court order. You can work with the legal system. You can get a court order, but usually it has to be like a certain amount of value, up to $5,000. If you are in this situation, we highly recommend that you get legal advice because, again, with real estate, as we've mentioned many times, different states and different areas may have different laws, and different jurisdictions may have different laws of what they consider, what they will and will not do. So you really need to talk to a legal person in the jurisdiction you want to retrieve your property to be able to understand exactly what your rights are and what they recommend that you do if you have your property in someone else's house. But the number one thing you should not do is enter that premise without any permission at all, because that will be considered burglary, and that could put you in a lot of trouble. This is Anita from Real Estate Crunch. Thank you so much for listening. We appreciate you and your time. If you've enjoyed this, give us a thumbs up, subscribe to us, and become part of our community. Thank you.